Good afternoon, and thank you for joining this month's webinar from the Labor and Employment Team at Brooks Pierce, the new normal, responding to remote work requests. Against the dark backdrop of a global pandemic that has claimed more than 1 million American lives and is now in its third year, employers continue to grapple with workplace changes wrought by the pandemic, including shifting expectations of where work is actually performed. 2 years removed from stay-at-home orders, workers are continuing to return to the office, but empirical and anecdotal evidence confirms that increased remote work is here to stay in what some analysts believe will be one of the largest societal changes in the workplace since World War II. In this webinar, my colleague Sarah Saint and I will attempt to give you practical guidance on what to know about responding to remote work requests. First, some housekeeping items. This webinar is for educational purposes. It is not to be taken as legal advice. We, of course, would be happy to provide legal advice in a confidential setting should you contact us, and we would obviously encourage that. Remote work requests in particular are very fact specific, so the guidance we offer here today are designed for you to issue spot and give you good practical pointers, but again, it's not a substitute for legal advice. We were happy to take questions throughout this chat. You can put your questions into the chat box and we will try to answer them if appropriate as they come up, or try to get to them at the end depending on time constraints, but we certainly do encourage you to use that chat feature. This presentation is approved for SHRM credit, SHRM credit. That code will be available, like all of our presentations, at the very end of the presentation, in which you'll have a chance to take down that code. So please stick around. Additionally, probably tomorrow, these slides will be emailed to you so that you have them available to refer to. And the presentation as well will be posted on our website in case you want to access it again. A little bit about ourselves before we dive into this topic. Again, I'm DJ O'Brien. My practice is focused on litigation and counseling for employers with a focus on employment litigation, the False Claims Act, and complex litigation. I'll turn it over to Sarah to say a little bit about herself.
Hey everybody, my name is Sarah Saint. I also do a lot of work with employers, everything from advising on hiring all the way through firing and then anything in between. I litigate as well, like DJ does, defending employers in litigation whenever necessary, particularly in this discrimination context, but also in protecting trade secrets and those sorts of things.
Thanks, Sarah. And with those preliminary matters, let me set the table with a not so hypothetical. Our clients are at different states of dealing with the pandemic in terms of opening their workforce. Some shut down completely and barely reopen. Others maybe stayed closed for a short period of time during the stay-at-home orders, but then completely reopened. And some other ones are somewhere in between. And so in this hypothetical, we imagine that you can apply it to your own situation at your workforce as to where you might be. But from what we're hearing from clients is a consistent message is that employees nowadays have an increased both desire to have more remote work opportunities. They also have more leverage in this employment market to require it in some circumstances. For some people, it's based on fear of the pandemic. Others, it's based on convenience, perhaps concern about the politicization of masks and vaccines. Others simply prefer to work from home, perhaps like Sarah and myself, they enjoy having pet coworkers around them, as we do not have actually in the office. People are at different stages, employers are grappling with this, but our point today, of course, is that we believe that remote work and those requests are here to stay. Remote requests have always been a potential reasonable accommodation under particularly the Americans with Disabilities Act, and we're seeing an increase in that. With respect to the new normal, the statistics show that there is at least an interest on both sides in accommodating these requests. I won't go through all the statistics that are out there, but they seem to be confirmed, corroborated by other sources as well, in that, as I stated, some employers are at different stages of reopening, but the concept of a return to normalcy, that we would somehow go back to 2019 or even February 2020, is a fallacy. for most employers, that there will be increased remote work expectations. Hiring practices generally move very slowly, but when you have a seismic event such as a world war, or in this case, a global pandemic, it tends to increase societal changes. Sometimes it reverts back, but it leaves lasting imprints. And we believe that remote work is going to be one of those lasting imprints because people have experienced it. They've had taken away different expectations from it. And then again, we believe that employees are going to have increased leverage to demand this as part of taking a job or continuing a job or refusing to quit. Additionally, we believe the pandemic has increased burnout rate, and there's a lot of apprehension about going back to the office. So with that, I'll turn it over to Sarah to talk a little bit about some of the interactive processes that most of you are probably familiar with in an HR capacity or in-house counsel role, but talk about specifically with respect to remote requests.
So we set up our conversation of you're being inundated with these remote work requests, and they come from primarily 3 avenues. The big one, and perhaps the most protected one, are disability related requests. And so we want to spend some time talking about this today. We're also going to talk about religious accommodation related requests, and then just lifestyle requests, people who enjoy working from home, people, as EJ said, who have pet colleagues that they like working with, or it's easier for childcare, or they just enjoy it. They like being able to eat lunch at home. So we're going to talk through all of these. The disability related requests is the one where employees not only have perhaps an upper hand in the bargaining power, but also it is important for employers to be able to grapple with when is remote work a reasonable accommodation and when is it not. So I want to take it back to basics. Y'all are probably very familiar with the concept of reasonable accommodations under the Americans with Disabilities Act. It's important to remember in this context, as well as all other contexts when talking about reasonable accommodations, that an employee doesn't have to use any sort of magic words. They don't have to say, I want a reasonable accommodation, I have a disability. There are a lot of different ways employees can approach their employers, their supervisors, wanting to request a reasonable accommodation, but not having the right words. And so it's important to continue to train supervisors, HR professionals about what kinds of things they may hear that would trigger, oh, we need to have a conversation about reasonable accommodations. And it's very important to remember that under the ADA, disabilities is a very broad definition. It is simply a mental or physical impairment that substantially limits a major life activity. And courts really defer to the employee as to whether or not they have a disability. So then we have to start looking at what sort of accommodations are reasonable for them. So this could be perhaps a remote work accommodation could be requested because somebody has asthma or has an immunocompromise or have cancer. Therefore, they're asking for it because they are susceptible to severe outcomes from catching the coronavirus. It could be that they have ADHD or another executive functioning disability, and perhaps they just work better from their remote environment where they don't have as many distractions. And then perhaps there is employees who have always have anxiety or perhaps have developed anxiety over the past couple of years, and they want to talk about remote work as a reasonable accommodation for them. Remote work can be a reasonable accommodation across the board, that they forever perhaps need to be working remotely, or it can be intermittently to be able to attend a doctor's appointment that is closer to home, wanting to attend a doctor's appointment and then come into the office, so perhaps working remotely that morning or that afternoon. So there's a lot of different ways that a reasonable accommodation can come about where remote work or working from home is a good option. So it is important to remember that not just because an accommodation is requested doesn't mean that it is the accommodation that has to be given. And so, as DJ said at the very beginning of this, all of these conversations need to be carried out in a case-by-case, very fact-specific manner, addressing, is this something that, does this person have a job where remote work is the right option for them or an available option for them, or do they need to be in the office and we need to look at different other sorts of accommodations that may work just as well for them. Not all jobs are able to be done remotely. And so it's important to, again, engage in that process of talking through what the person's job functions are, what can be done remotely, and if there are alternatives to remote work as an accommodation. So some best practices in this. Number one is making sure that your job descriptions are up to date. In order to have a conversation with somebody about remote work and whether that is an accommodation for them, it's important to know what their jobs are and whether or not they're able to work from home. Many of us started working from home as soon as the governor in North Carolina closed down schools around March 14th of 2020. Sometimes that meant that we could do our entire jobs remotely. Sometimes that meant that a lot of people's essential functions just weren't happening. And so just because someone was able to work from home doesn't necessarily mean that they were doing all of their essential functions. And so it's important to make sure that those are up to date as you're responding to these work from home requests. Again, it's also important to remember there aren't magic words here to request remote work as an accommodation. We advise that employers should treat any remote request having to do with a medical condition, whether that's a physical illness or a mental disability, as an accommodation request, and beginning that interactive process of what are good options for you? Are we able to make this work or not? I mentioned this earlier, but past denials of work from home as a reasonable accommodation may need to be readdressed. Our firm and many other workplaces have a lot more technology capabilities than they did 2 years ago. And so remote work may be more available now for employees than it ever was before, simply because the company has invested in more technological resources. And then finally, and this is another one of those case-specific analyses, is that work from home accommodations may require reimbursement for home office equipment. Someone who may need a standing desk at home, somebody who may need a computer or the ability to use their office phone line from their cell phone. And so the analysis doesn't always end with, yes, you can work from home. It may also need to continue into what are things the employer needs to do in order to make that possible for the employee. Religious accommodation requests are very similar to disability-related requests. It could be that somebody wants to work from home to be able to attend a religious service that is closer to their home. It could be that someone wants to work from home because they fast as part of their religion. And that's easier to do when they're not smelling pizza in the break room or those sorts of things. So you may also get religious accommodation requests if you haven't already. And the analysis is pretty similar on the religious end. It is trying to eliminate a conflict between religion and the workplace. And this is all under our Title VII that I'm sure many of y'all are very familiar with. But you're also asking the same sorts of questions. Is this reasonable for them to be able to work from home for religious reasons, or would that cause an undue burden for the employer? So it's the same kind of conversation about, is there an undue burden here for the employer in order for someone to work from home, whether that be disability related or religious related. And so it's undue burden is not just a simple financial analysis in either of those circumstances. And it's certainly not on the religious accommodation request. So again, the interactive dialogue between the employer and the requesting employee should be one that is done on a case-by-case basis, not blanket rules set forward by the employer based on work from home. And so these requests, even if you decide we don't want anybody working from home, you still may need to provide reasonable accommodations for disability reasons or for religious reasons. I'm going to turn it back to DJ to talk about other instances where someone may request working from home and what employer requirements are there.
Right, especially with the pandemic, there may be some more lifestyle requests for the reasons we've talked about earlier, in terms of people feeling like they can work from home and be productive, and it's just wanting to be there. Outside of religious accommodations or disability accommodations, employers are likely to have a little bit more leeway with respect to lifestyle requests, at least from a legal standpoint. However, the big important caveat, probably the exception that swallows that rule, is that you've got to be absolutely consistent. So there's some important considerations when an employee comes to you requesting an accommodation essentially for their lifestyle, their preference to work from home. And the main thing, of course, is to be consistent, not necessarily with we're going to grant every application or we're going to deny every request, but to be consistent with respect to how you're going through that process. With respect to what work can be done remotely, can a person sit in front of a computer, like, for example, a lot of lawyers for large portions of their time, and participate in Zoom, draft documents, communicate with colleagues via email, or is their physical presence required? And I'm not just speaking about, for example, is someone needed to lift something from point A to point B, but are there other requirements of a traditional desk job that do require physical presence? There's some employers who believe that it's absolutely essential to have a team together to be able to confer, whether or not that's scheduled meetings, but just bumping into each other in the office. So it needs to be focused on what that specific job can do and if it can be done remotely, and then with respect to its effect on the other teams. So we encourage people to review the job descriptions and duties in assessing those applications. And then again, consistency is key. The criteria has got to be objective. It's got to be legitimately based on business reasons. And again, consistently applied. That's where employers will get into trouble if it seems that they're favoring some employees who may have a preference from working from home and versus others. So let's say that someone has not put forward any magic words or has invoked what would be a substitute for magic words as to an accommodation with respect to religion or disability, but simply wants to work from home. That interactive process is still the way to go about. It may be a quick interactive process depending on the position, but it may be more in depth. And the key is to be consistent. And also it needs to be documented. Decisions that can be made based on conversations in the hall, over the phone, or even over email may not accurately reflect the decision that has been applied. The EEOC has already been active on this front. Within the last year, it filed a lawsuit in federal court in Georgia against a company for its decision to deny an accommodation request. In that particular case, there's lots of overtures about disability accommodations, but it was also rooted in lifestyle. The key is, I think the EEOC is going to be looking for disparate treatment in these categories. And so they're going to want to see that you have a policy for addressing these. Maybe it's not in your handbook, but it needs to be a policy that's thought out and applied even-handedly. With that, I'll turn it over to add a little bit more detail to the not so hypothetical that Sarah and I have laid the table for.
Thanks so much, DJ. So now we've gone through when somebody may request remote work, when an employer is obligated to provide that sort of remote work, if it is a reasonable accommodation for disability or for religion, it doesn't present an undue burden to the employer, but you've certainly decided that you are going to look at remote work requests on a case-by-case basis. Some people may be working from home, other people may be in the office. So the people that are working from home, there are a lot of considerations that employers never have to think about when people are in the office. People may be working from home, but actually in a completely different state. They may not live in North Carolina if you're a North Carolina employer. They may live in Chicago. They may live in California. They may spend 6 months of their year in France and 6 months of their year in North Carolina. And so employers need to think through, what does that change about my obligations to this employee if they are in a completely different state? Sometimes a different state's minimum wage laws may apply. Sometimes different states' overtime laws may apply that provide for a higher minimum wage or different overtime requirements than North Carolina does. Questions may come up of, how do we track hours? We usually use a clock in, clock out process. Now people are working at home. How are they clocking in and clocking out? What about our confidential information? People are going to have databases in their homes where someone could break in and steal their information, or if they're working from a coffee shop, somebody can come over and take their laptops, take their notebooks. What are we going to do to protect security threats from someone's home network? Can we monitor employees? That's a question we get a lot in our office, is what sort of monitoring can we do of our employees when they're working from home? How do we make sure that they are working? What if there's harassment? What if somebody is harassing somebody on Teams or on Slack? What's our obligation as an employer to handle that if that's happening not here in our offices? What do you do if somebody gets hurt at home? Do these have the still same workers' compensation requirements? So work from home is not as simple as, yes, that's fine. Here's your computer. We'll see you in 6 months when you come have a check-in. This is not business as usual. And there's a lot of things to think through, even after you decide that somebody's able to work from home. So important general principles that will guide us through the rest of this presentation. Employees who live in different states may unilaterally require employers to comply with different states' laws that an employer was ever expecting to comply with if they are working from there. And that changes on a state-by-state basis. Employees are still protected from the employment protections available to them in the office as they are when they are working from home. Your company's rules and policies should apply equally from home or the office, or have a very clear rationale of which ones do or do not based on where people are. And the last thing that is important is that required workplace posters. So I'm talking about those break room posters, the EEO poster, the wage and hour posters. Those things still must be posted. But if somebody is working remotely, then they need to be accessible to them in another means, whether that's on a company intranet or a Google Drive or those sorts of things. So I want to talk first about the wage and hour issues, minimum wage, overtime, those sorts of things. As we all well know, the Fair Labor and Standards Act is our federal default, but some states have higher minimum wage requirements than North Carolina does. Some states have a reimbursement requirement for home office expenses, separate and apart from the reimbursement we were talking about with disability accommodations. And so it's important to know where your employees are working. You know, if they're not coming into the office, is that because they're sitting down the road? Or is it because they're in California? Because some states require employers, regardless of where the employer's business office is, to comply with minimum wage laws where the employee is, not where the employer is. So it's very important to know where your folks are and then what the minimum wage requirements are there. Same thing with reimbursements. The Fair Labor Standards Act, the national default, doesn't have any sort of reimbursement requirement unless out-of-pocket expenses would lower someone's pay to be lower than the minimum wage. But a lot of states do. That includes California and Illinois and New York. And New York's is even a misdemeanor if an employer doesn't provide for reimbursement. So these are things like internet, cell phone use, printers, ink, those sorts of things. Some states even require home utilities to be paid for if someone is working from home. Meal and rest break laws, those differ from state to state. Some states have longer meal and rest break laws, and many states require us to look at where the employee lives, not where the employer is situated. And then the last one, and this has been growing over the past 4 or 5 years, are paid transparency laws. Some states require when jobs are posted that they disclose a salary range, or that you're not allowed to ask an employee what their previous salaries were. North Carolina doesn't have a law like that right now for private employers, but other states do. And if you're hiring people to stay there and to work there, you may be subject to those laws as well. So it's really important to know where your employees are living. It's also really important to keep in mind exempt versus non-exempt employees. As we all know, exempt employees are employees that meet this minimum salary threshold, that have certain job duties, executives, administrators, professionals, those sorts of employees, and that they don't have overtime, right? They're exempt from overtime. And so if they work over the weekend, that's part of their salary. But a non-exempt employee, those employees must be paid overtime. And that's the same thing, whether they're working in the office or from home. And so because of that, recording time is very important, and making sure employees are keeping track of the hours that they are working, because where you don't have as much ability to monitor employees' hours, you're kind of on their own honor system, and you may wind up with employees earning overtime that you never intended for them to earn that overtime. So it's really important to review and perhaps revise your policies about when overtime is available, prohibiting off the clock work, and then making sure that employees are doing a good job keeping track of their hours. It's also important to remind supervisors about what hours count towards overtime. Off-duty hours are generally not compensable, but they have to be truly off-duty. And so while we're in the office, it's very easy to see, oh, that person has gone to lunch, they're not in the building, or they're in the break room, they're clearly on break. But when you're working from home and someone is available by their cell phone, picking up the phone and calling them is very simple. They may not be truly off duty anymore on their meal breaks or their rest breaks. And so it's important to look at and train supervisors as well as employees to know when they're expected to answer the phone from home and when they're not. And then also with those working in different time zones, it may require some finesse in considering schedules and what working day means to different people on the East Coast versus the West Coast. Leave laws also come into play here. Again, we have our national default, the FMLA, and leave taken under the FMLA has to be accurately recorded, cannot be interfered with, cannot be used for retaliation. But under a remote work world, we still have leave laws that if somebody is unable to work because they're sick or because a family member is sick, employers are still obligated to comply with these leave laws typically of the state where the employee lives. So again, North Carolina doesn't have very expansive paid leave, but other states do. Colorado residents earn paid leave, even working for private employers. California residents get to roll over their vacation time. So leave laws that are different in other states may end up applying to a North Carolina employer whose remote workers live someplace else. So it's important to know, again, where your folks are and then what those laws are that could be applying to your employees that wouldn't if they were actually in the office. And employees should continue to take leave if they're feeling sick. In the same way that if somebody's work effort suffers, if they're sick when they're in the office, and when discipline is able to be provided there, same thing if they're out of the office. And so again, it's important to encourage employees to take the leave when they need it, but also remember all the perhaps new requirements of the different states where employees are sitting. All right, DJ, I'll turn it over to you to talk about the money aspect of it all.
Thanks, Sarah. And consistent with what we've been talking about, obviously remote work increases the chances that employees may be in other jurisdictions. And we've indicated that those jurisdictions may have different laws and different requirements. One point I want to make is that just because you may have an employee, for example, for your North Carolina company that goes to work or lives in South Carolina or Virginia over the border, and you think you may be subject to those states' laws, you still can confer with your North Carolina counsel as to whether or not those laws may be applicable. You don't necessarily have to go to those other jurisdictions and hire lawyers in 50 states, for example. That lawyer, he or she should be able to accommodate you or tell you whether or not they can give you that advice. But transitioning over to the money aspect of multi-jurisdictions, this is a real headache for employers. It is very state specific with respect to withholding taxes and other tax requirements. It can be determined unilaterally, like we said, by where the employee lives, depending on the jurisdiction, if that employee is working from home. I want to go through some of these requirements to keep in mind. Another wrinkle to that, though, is that during the pandemic, some of these states have temporarily waived these requirements to allow for more people to work remotely as kind of an accommodation or recognition that the workforce has changed during the pandemic, and those may go away. And so we're obviously into, quote, a new normal, and we're seeing some of those waivers go away. And as a result, we're seeing compliance increase with respect to enforcement of these issues. With respect to taxes and payrolls, things to keep in mind: you're required as employers to withhold unemployment and state income taxes in the state where the employer's home office is located. So that's an easy one in many cases, if where the employer is located. But then with respect to the employee, if they unilaterally start working there, if you've approved it, you think it'll work well, then all of a sudden you're subject to those requirements. Other states are different, and they look for more of a connection. But in some jurisdictions, there's what's called a business nexus with that state, meaning if you've got one employee working from home, Zooming away, coming into the office once a month from another jurisdiction, you still may be subject to those laws. Employees also face different obligations, so it sometimes can be problems for them as they're subject to income tax in two states where they work as a practical matter, where they live, and then of course where their actual headquarters are. Maybe they have an office they visit once a month, maybe they rarely go there, but that's where primarily their work is directed. And then in states like New York, for example, just even getting beyond the state by state inquiry, you can get into even further into municipalities, that require even further compliance. So it's important at the outset to consider the effect on the business as to where the employee may be actually be working and what that's going to require you to do. So what are the best practices for assessing this? Obviously, knowing where your employees are is important. This is not an invasion of privacy. It's a legitimate inquiry if you think you may be subject to regulations, whether they're tax, payroll, others that we've talked about, as to if an employee is approved for working from home, either part of the time, full time, as an accommodation for disability, religion, or just lifestyle. It's important to determine where they are. Consult with counsel if you need to, and we encourage that, or payroll specialists, but look out for those withholding rules, those situations in which an employer has failed to withhold taxes in appropriate jurisdictions sometimes can be very difficult to unwind. So it's important to address that at the front end. And then look with respect to the obligations for each employee. There's certain registration requirements for payroll taxes in appropriate states. And then there's unemployment taxes that may also be paid. We're talking about a situation in which perhaps an employee is terminated, or they feel that they had to leave their job due to no fault of their own, and they apply for unemployment taxes, unemployment benefits, and all of a sudden you've got for example, Virginia employee who is now seeking compensation for unemployment, for which you've got to deal with. And there may be requirements on the front end and then on the back end. And I think it's helpful for there not to be any surprises. So with respect to number 6, inform employees of the additional requirements. To the extent that this is going to be an issue, you don't want it to be a surprise for the employee. Obviously, when there's something happens that's a surprise for the employee, they look to the employer, and there tends to be litigation at worst, or at least issues that must be addressed. Relatedly, insurance coverage is another issue. In North Carolina, for example, I believe the standard is 2 or 3 employees for which you've got to have insurance, for example, workers' and compensation coverage. That can vary via jurisdiction. And so you may think that I've done everything I've needed to do with respect to North Carolina's workers' compensation laws. And then it turns out that the analysis has not been made with respect to another employee in South Carolina, somewhere else, as to what the workers' compensation issue could be there. So that's the number of employee analysis. That's kind of the threshold issue we're always trying to look at. And that can vary frequently pre-pandemic, during the pandemic. I won't say post-pandemic, because I don't think we're quite there yet. We get some issues from employers who were small or didn't think that someone qualified as an employee, and therefore they didn't have the insurance. And within the last 10 years, there has been increased enforcement, and the penalties are more severe for failing to have that coverage. What happens is if you don't have the coverage, you don't have insurance counsel defense. And so you're faced with paying for your own defense. You don't have insurance for it. You're also on the hook for daily fines, weekly fines for not having that coverage in place. And then, of course, in the worst case scenario for everyone, an employee is actually injured, perhaps severely, and that person does not have coverage. And it very well could be that the employer is having to pay that out of pocket. And we think about, well, perhaps, remote work won't be much of an issue if they're working from home. I don't really need to worry about workers' compensation, about injury, and we'll talk a little bit more about that. That's not the case with respect to not being on the hook for these type of workplace injuries. So the key is, again, can't emphasize it enough, states can differ in their requirements, and as more and more employees are approved for remote work requests or simply are allowed to work more remotely, those laws could come into effect. And it's not the situation, I don't want to leave anybody with the impression that, well, if a person who happens to live across the border in South Carolina, but works for me in North Carolina most of the time, is occasionally working from home, they're automatically subject to every Virginia or South Carolina law, depending on where they live. That may not be the case. These requirements can vary, not just state by state, jurisdiction by jurisdiction, but also with respect to the particular concern that's trying to be addressed by these laws or regulations. So keep in mind that not all employees count under every state's laws. Sometimes a saving grace is if it turns out either just through luck or perhaps analysis on the front end that employee actually doesn't count to trigger that requirement. In speaking of that, it turns me to the next slide, which is the classification of employees. I guess about a year ago during the pandemic, I gave one of those presentations that many of you probably have participated in before, which is with respect to employee versus independent contractor. That analysis has been the subject of litigation. It's changed based on which administration is in control. It's changed based on states. In green, the number one concern is listed on here is the degree of control. It's somewhat unfair for employers with this kind of shifting landscape as to, with respect to one standard seeming to make just about everybody an employee, and then the other standard seeming to try to allow employers to classify people as independent contractors. And our point in bringing this up here, and again, we've had presentations on simply the different standards for classifying independent contractors versus employees, is that with remote work, you could actually shift a little bit more toward an independent contractor status if you kind of lose some degree of control. That may be a great thing in your mind, or it also could trigger some other possibilities. We have lots of resources for going through that analysis. It's very, very fact specific as to when someone is an independent contractor versus an employee. There are lots of guidance from the Department of Labor in particular as to particular job classifications. But oftentimes we get an inquiry from an employer saying, well, this person has this position, so they obviously can't be considered an employee. But it turns out actually that they're closely supervised. There's a lot of control over that. And so is where maybe there's a presumption that this person would be an independent contractor. In reality, it's not. So it's not just job description. It's not just, job title. It's also what are their particular duties. And, keep in mind as well that you can have an employee for different purposes. It's not just the independent contractor versus employer standard. It matters for payroll purposes. It matters for other compensation type purposes. It matters for harassment and discrimination laws. You could have someone who is an independent contractor, but depending on what they do, they might be a joint employer with someone else for other reasons. There's all kinds of different ways, and oftentimes, and I imagine Sarah gets the same inquiries, the concept of exempt versus non-exempt and hourly versus non-hourly gets confused with the classification of employee versus independent contractor and then for what it is. So it really can be context, not just fact specific, but context specific. What's the specific purpose for which there may be a concern? I want to turn it over to Sarah now to talk about some of the privacy concerns that emerge with respect to remote work.
All right, thanks, DJ. So with remote work, as DJ and I explained, there are a lot of considerations to give, considering where employees are, what they're doing, how their jobs have changed. But that's not all. We now have people who are carrying company confidential data to their homes, to their mountain vacation house, on an airplane to Ohio, all different places. And so it is important for employers to consider, what is that confidential information? How do I keep it safe? And what am I able to do? What are some ideas of what to do in terms of making sure that as that information leaves the protection of my four walls, what I can do about that to try to keep it protected, keep it confidential. So looking at that confidential information, this can be everything from your trade secrets, the way that you run your business, the way that gives you that competitive advantage in the market, what you wouldn't want your competitor to know anything about. This could also be customer and client data. For some companies, that information is a trade secret and is protected in that way. For other companies, doctors' offices and those sorts of things, that information is protected by several laws, the HIPAA concerns or privilege concerns, as well as it being confidential information for the company. And then also, and this is an important one, if there are HR professionals or supervisors who are working off-site, who are working from home, they may have access to medical information of employees, which is protected under the Americans with Disabilities Act and some other laws sometimes too. And so it's really important that we're keeping this confidential information confidential, whether that's because it is important to your business or because there are other privacy laws that make you protect it and keep it safe. And so it is really important to kind of think through, what are the kinds of information that are now leaving my four walls that I need to keep safe. And so I think the overarching best way to handle this is to stay vigilant and to learn about information technology in ways that I certainly didn't know about before the pandemic. And I think a lot of people are becoming more well-versed in working with IT professionals to look at your systems, to look at your clouds, to look at who has access to what information, understanding what sorts of attacks are in vogue right now. They change every so often of what kind of attacks are happening, and really in training employees and training supervisors and managers about how to avoid attacks, whether that's through webinars or pamphlets, but helping them know these are protected ways to keep information safe. These are ways that make us vulnerable to phishing or to spoofing or other sorts of attacks that can come in from the outside. And then again, importantly, because people are not within the four walls anymore, if somebody leaves the company, whether they're terminated, voluntarily leave, retire, what have you, they have reams of confidential information now at their house. How are you going to get it back? How are you going to make sure that they don't keep any of the information that has left with them while they're, whether they're at their mountain house or wherever, so that you can make sure that you have that information back, whether they're giving you back their computer, giving you, cutting off their passwords, collecting the information, having them shred it, but really making sure you know what the plan is when that employee no longer works for you. And then also what you're going to do if that employer, if that former employee violates that policy. And there are some pitfalls in that. If the answer to that question is you're going to reduce their pay for their last paycheck, some states require that to be agreed to in writing in advance. Other states don't allow that at all. And so again, we still have to go back to that jurisdiction by jurisdiction analysis to make sure that we're applying the right state's laws and figuring out what the plan is if that employee never gives their confidential information back. So some things to think about, some ideas to consider as you're thinking through, what am I going to do to protect this information? Certainly, and this goes for most policies that DJ and I would ever help write for you or advise you to write, having an acknowledgement, a written acknowledgement that from the employee that says, I received this policy, I have read it, I agree to abide by it, and keeping that signed information so that you can say, you were aware of this policy, you agreed to it. There's a lot of different sort of technological ways that you can protect information, be that encrypted emails, requiring employees to use the VPN, or only allowing them to be able to access company data if they're using a VPN to protect from outside attacks. Password protecting data, password protecting home Wi-Fi routers, having certain password requirements, avoiding public Wi-Fi. A lot of attacks come through these open networks, public networks. What to do if they get a suspicious email, how to identify a suspicious email, what traits to look for in those emails, or website links, or email attachments. There are some cloud servers that are more prone to cyber attacks, and making sure that employees are not using those cloud servers to store confidential company information or confidential employee information. Requiring employees to keep their devices separate so that they don't have their child who is at home learning or working on homework using the company computer to do that, and perhaps finding confidential information or sharing confidential information either accidentally or on purpose. But really having strict policies in place about what employees are allowed to do with company property or BYO property, and what they're not allowed to do. And then also having shredding policies. We don't want confidential information or HIPAA protected information being thrown into just the family recycling bin to go off to the landfill, but having some sort of shredding policy that applies to employees when they're working from home as well can also be helpful. And the last one I'll bring up, and as DJ's pointed out with the independent contractor analysis, we have done webinars on this topic where we go very in depth about non-competes, but a non-compete could be a really great method to keep your information close, to keep employees from being able to use that information as they move on, or even to be able to move on to work for a competitor of yours. And most of the time, North Carolina law will apply for non-competes with North Carolina employers. But if we have employees that are working in California that completely prohibits non-competes, or in other jurisdiction that has different limitations on what a non-competition agreement can do, or what it can say, then we may have to go through again that jurisdiction by jurisdiction analysis to determine what would be a reasonable non-compete there. And we have to look at, where would this non-compete be litigated? If someone violated it, you sued for a breach of contract, where would that trial happen? What laws would apply? So again, we're coming back to, where is the employee living, and does that law, is that state's law able to reach a North Carolina employer and a North Carolina written non-competition agreement? So there's a lot of different methods to protect the private data that you need to keep private while your employees are working anywhere and everywhere across the country. And I think that this is important even for workplaces that are hybrid, where employees are coming in and out of the office, whether they're even if they're not work from home all the time, even if they're not leaving North Carolina at all. This is something that I think a lot of employers need to be thinking about now more than ever, as workers are working from home, even for short periods of time. These are the kinds of things to be thinking through about, how do we keep our information ours? All right, DJ, now I'll turn it over to the other side of privacy.
Right. Certainly confidentiality concerns fit within a legitimate concern for employers. Another concern we hear about, and it was certainly heightened as soon as the pandemic hit, with respect to remote work, was I need to be able to make sure my employees are actually working. From what we can tell, I think a lot of the concerns from employers regarding some of the concerns about remote work and decreasing productivity have largely not played out. And there are some reports that productivity has increased. Again, I think it could depend on the type of work, the type of individual. But in March, April of 2020, we received all kinds of requests for information regarding what types of monitoring they can do of remote work. Additionally, the statistics show that Google searches, for example, for employee monitoring for software exploded. I won't spend much time on this slide because I want to make sure that Sarah has plenty of time to talk about employee safety and well-being, but there is a lot of software out there that allows employers to track what their employees are doing. And the pitfalls there are that you can overstep your bounds. You can, whether or not the person's using a personal computer or a work computer, you can still find out information you really don't want to know, whether or not that's legal or not, whether or not it causes a problem with the employee and trust issues right there. We've done plenty of presentations on social media pitfalls and the laws out there with respect to information that's shared, information you may learn as a result of social media. But you can learn that same information by monitoring an employee's use of their computer. And you find out something, for example, with respect to, for example, a disability, their religious preferences, that could cause information that you really are not trying to rely on to make a job basis. So there's all kinds of concerns out there with respect to monitoring. Some software is better than others, but even the very best software, the very worst software can be abused and cause you some issues. So we've listed some best practices there on the far right. Again, these slides will be made available to you as a participant within the next day or so with respect to how to communicate, how to enforce monitoring of employee activity, particularly for those who are working remotely. I think the key is to manage expectations, that second one there, so that people avoid, if they've got something they don't want their employer to know, that's not a legitimate concern for their employer to know, that it's not involuntarily shared with the employer. The employer never wants to learn something that they ended up learning that has nothing to do with their job, but they end up finding out about it simply because they've got some type of software that may be over aggressive or overbroad. And again, be consistent, don't retaliate. And to the extent that there are legitimate concerns with respect to confidentiality, employee performance, productivity, that it's carried out consistently for a legitimate business reason. With that, I'll turn it back to Sarah to talk about employee and safety well-being.
Thanks, DJ. So I mentioned this at the beginning of the presentation that employment rights stay with the employee, whether they are at the office, working from home, working from their beach house, on vacation. There are still protections for employees that apply regardless of where they are, simply because they are an employee. And one of those big ones are the protection from harassment, from workplace harassment. We, again, like most things, we have a federal default that most of it is set forth in the familiar Title VII, but some states have more expansive civil rights protections. Some municipalities have more expansive civil rights protections that, again, require us to know where people are to determine what laws apply. But harassment is something that continues to be an issue in the remote workplace as well as in the physical office workplace. This can be cyberbullying on email or text. It can be verbal bullying, everything from a raised voice, snarky comments, those sorts of things in virtual meetings. It could be inappropriate comments or inappropriate conduct. And then the standard sexual harassment can certainly continue to happen over the internet or on the phone. And in some ways, harassers can feel emboldened by the physical distance, by a feeling of anonymity. And so it could, for some places, maybe heightened harassment. If that was a concern before, it may be even more of a concern now. And it's something certainly to pay attention to. It's even harder today, though, in the remote environment for employees to come forward with harassment because they may not be as close with their supervisors. Supervisors may not be able to see it as easily. And so it's important to train managers and supervisors of what to look for, when to be concerned, what red flags should be going off in their heads as they're working with their employees in the remote environment. DJ, I'll let you talk about the physical injury side of things as well.
Sure. And the concept of telecommuting, working from home, and with respect to employers' obligations for ensuring a safe environment has been a subject of controversy since at least the 1990s, when OSHA promulgated some standards for telecommuting. And we're not just talking about workers' compensation laws, we're talking about just generally having a safe workplace. OSHA doesn't wait necessarily for an injury to take place before they come in. So what's the scope of what they're going to expect for you to be regulating with respect to remote work? As Sarah's indicated, two things, state by state, it can vary, even though there's an OSHA national agency. Workers' compensation can vary. And then I think it's also, the key thing is, OSHA is going to be concerned about employee safety regardless of where the work is performed. If the work is performed in the course of employment from home, it's going to fall within a legitimate OSHA inquiry. It doesn't necessarily mean the employer is going to be on the hook for every home injury that happens. It has to be within the course of the employment. It's really a tough dichotomy that is out there right now legally, which is that there's generally no duty to inspect a home office if you've approved remote work, generally. But there still could be a hook for liability. We've got one example of tripping and falling over, as Sarah and I have indicated, one of our furry coworkers, which obviously happens from time to time. Is that a workplace injury? It's not as clear cut as most people on this webinar are probably on the employer side. It's not as clear cut as you might think. There's some real pitfalls there. OSHA's typically not going to go and inspect home offices, but once there's an injury, they're going to look to see, was there any type of notice to the employer that there was some type of situation there, not just for workers' compensation purposes, but for other purposes as well. So it's a real problem there. You have a lack of control over a home office. You don't have a duty to inspect the home office, but yet you still could be on the hook for those types of questions. They can be addressed on the front end. And so that's why we put in this slide here, best practices for trying to ensure that you're not going to allow somebody to put you on the hook for what really is a home injury unrelated to work. And that has written authorization before an employee can work from home. They have to be approved to work from home. That could be a very important analysis. If they're working from home on their own volition without approval, that really could insulate you from liability. If it's outside their job descriptions, even if it's somewhat related to work, that might be helpful as well. You want to know about those injuries immediately. You want to maintain any logs, any documentation that you need to. There may be opportunities to provide safe training about workstations at home. We certainly have seen those. There's good resources out there. Apart from just consulting with an attorney, there's some good HR guidance there, depending on the job, of course. I think a key piece of advice that we have given in a confidential setting to some employers based on their specific needs are to have set work hours. People have different expectations or different energy levels depending on the day. And some people like to work at night, some people like to work at morning. And so the concept of being free from the 9-to-5 job is liberating if they can work after dinner, if they can work early in the morning, depending on what they want to do. But that creates pitfalls. When is the workday? If an injury occurs outside of the workday, unrelated to work, it's potentially not something that should trigger liability for the employer. But if it's not set for remote workers, somebody was working off and on all the time, maybe they're super productive and generating a lot of great work, but they work all the time. And then they have something that happens to where they have a workplace injury in their home. It could be harder to define. So there may be opportunities there as a practical tool to set those hours. And so with that, I'll turn it over to Sarah to close this out with some parting thoughts. And obviously we'll give you that SHRM credit that we know you need.
Absolutely. Well, thank you all so much for listening and engaging with us today. There is a lot to take in terms of what to do when employees are working from home, how to answer remote work requests, when must an employer allow for work from home, when do they not, and what are some pitfalls to look out for. So again, we'll certainly make sure that you have this presentation, but it is important that that there are policies in place that make it clear for employees and employers about what we're going to do in this new normal, that those are in writing and that employees for sure know what those are. It's also really important to remember, where are the employees located now? Are there requirements that can be set forth where employees are only allowed to work in certain places? Or if there needs to be, you need for them to be available to come to the office from time to time. So there's a lot to keep in mind as we move forward into this new normal here. I wish we had some time for more questions, but we have run to right at that 1:30 mark. So I'm going to turn over to our SHRM credit for you to be able to take this down, but we will certainly make sure you have these slides. And then if you want to have a conversation with us later, we're more than happy to do so.